it. And that's the type of literature they provided about these.
But if
products.
the agency says that doesn't outweigh the harm to youth, we've reviewed everything, we're aware of everything. Of course they're aware of everything that's out there. It's kind of the end of it, isn't it?
Well, Your Honor,
I mean, you disagree with the statute giving that much discretion to FDA, and you disagree with FDA, to Justice Sotomayor's point, weighing of the two parts of the balance. And I understand that, but trying to figure out what the legal error is there.
The challenge here is procedural, Your Honor. It's procedural. It's a change in position. So
I understand that. I'm just making sure there's not, you agree that at the end of the day, the agency has to make a choice, and it's going to be a choice with uncertainty.
It has to make a choice, but when it changes like it did here, what that test is going to be, or its interpretation of the statute, it has an obligation to identify the fact that, to realize the fact that it's making a change and what it's communicated, to consider less drastic alternatives, such as the option to give applicants an opportunity to go and conduct those studies, which is what we're seeking here.
And I know what you're seeking here. I'm sorry to interrupt, but what exactly would be, this is the question I was asking Mr. Gannon, the relief that you're seeking in terms of what it would cause the agency to do as a real-world practical matter?
So practically, to have the marketing denial orders vacated and remanded, as the Fifth Circuit did. And I'll point out, we don't—
That wouldn't allow you to start selling the product.
Well, because of the deferred enforcement policy, our clients are still allowed to sell the products, but that's because of FDA's policy. It's a fairly unique circumstance here. Right. I recognize that.
Yeah.
And frankly, we don't know how FDA is going to approach it on remand. We have a new administration coming in. The president-elect is on record saying, I'm going to save flavored vapes. We don't know exactly what that's going to look like. It may be that the approach the agency takes is much more aligned with the statute and looks at all the risks and benefits.
But you could reapply all those things you talk about in the political process. You could reapply, and all that could happen through that process, right? In other words, I'm trying to figure out what's different from reapplying, just reapplying, and what's different from reapplying after a vacator.
The distinction here with respect to respondents specifically is they're going to have to close their doors. If they are, this in effect is punitive for them, because reapplying, closing down, and the matter is, even though the statute calls for decisions in 180 days, FDA is taking 3 or 4 years at least to make determinations on these. They can't afford to wait that out. If these MDOs are not vacated and remanded back to the agency, they're closing their doors and they're done. This was their one shot. That's why it was so important for FDA, when it changed its position, to communicate that and give them an opportunity to meet the new standard, and that's what was denied here.
Okay.
How is your position